Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. Well, welcome to episode 2. We're here with attorney Jeff Roberts in Murray, Kentucky. Jeff handles a lot of workers' compensation claims. And today we're going to focus this episode on workers' comp benefits, the process, things like that, and going to give you an idea of what you might be able to expect. Jeff, welcome back, guy.
Thank you.
Absolutely. Hey, let's jump in. Why don't you take the lead on this and talk to us a little bit about, what qualifies an injury for a workers' comp injury, obviously, and then kind of walk us through the process and what I might expect if I've been injured on the job.
Okay. If you've been injured, first off, let's start off that workers' comp are kind of broken up into 3 different potentials. You've got a workplace injury, which is generally a physical injury to the person. You can have an occupational disease that results from exposure at work. A lot of people
chemical exposure,
coal dust exposure, black lung, for instance, is a well-known occupational disease, and then also an occupational hearing loss. So all 3 of those can form a workers' compensation claim. Now, in far western Kentucky, where I practice at, generally, we're looking at either a workplace injury, a physical injury, or hearing loss because there's no coal mines in this area. But I have been involved in some occupational disease cases from heavy metal exposure and even some black lungs of people from the Madisonville area that wanted me to handle their claim and come down here for me to be able to present their claim for them. But I'm going to focus more on the physical injury type cases because that's what we see more down in this area.
And to be clear, just because you're in Callaway County doesn't mean your comp practice stays in Callaway County. I mean, you do handle cases throughout the region. I
handle workers' compensation cases all over the area. The workers' comp hearings out, the closest one is Paducah, but I handle anything in what I consider Western Kentucky. I've handled numerous cases out of Bowling Green with the General Motors facility up there. In anything west of that, I've handled workers' compensation claims in all of those. I've handled cases in other areas of Kentucky as well, but primarily focused basically Bowling Green, west and south.
Okay, so when you mentioned Paducah, that is where that court is actually located. That's where a lot of these cases are argued, basically.
That's where they're heard. Yes, okay. The hearing site is in Paducah. The next closest hearing site is Bowling Green, so I have cases in Bowling Green and or Paducah on a regular basis. Yes.
Okay.
Yeah. But when someone is injured on the job, the first thing you need to do is actually notify your employer that you've been injured. And the Workers' Compensation Act specifically says you have to give reasonable notice of a workplace injury. And as you can imagine, what is and is not reasonable is subject to interpretation. If you give notice the day of the injury, you're obviously very good from that standpoint. But it can be even a delay in notice and you will be fine.
Well, you get knocked out, they take you to the ER. Obviously, you can't wake up and go, hey, I was hurt at the job.
That's correct. But if that's the case, an ambulance picks you up and takes you, they have notice. You don't have to actually be the person to give notice. They just have to be given notice. So if you get knocked out and a coworker tells the supervisor, Jim got knocked out, we need an ambulance here, then they've been given notice at that point in time. And I've got a funny account of an insurance company denying notice that I can talk about later. But at this point, you want to make sure you give reasonable notice.
And that has to be to the employer, so not your union steward. That doesn't count.
Right.
It needs to be an employer, a manager, a supervisor.
It needs to be someone above you in the food chain.
Okay.
So your supervisor or plant manager or whatever. And it doesn't matter what the company policy is. We're talking about Kentucky law here. We're not talking about company policy. I've had a lot of clients come in and say, well, I went and told them about this injury, but they said I didn't report it in the first 24 hours, so I can't pursue a workers' comp. So it's not covered under workers' comp. That's absolutely incorrect. If you give notice, and it doesn't have to be 24 hours notice, then you can still pursue the workers' compensation claim. So if the employer or the insurance company complains about the notice or says because you didn't give notice in a certain time frame or to the right person. So if they say, well, you told your supervisor, but you didn't tell the human resources department, and that's what our policy says you have to report it to human resources. So we're not going to file this on workers' comp. You need to call an attorney because that is not Kentucky law, and that does not affect whether you can pursue a workers' compensation claim or whether they need to be paying for your medical bills.
Let me just ask the obvious question. Why would a company want to play games like that? What's in it for them?
I really don't know, to be honest with you. My assumption is that they think that it's going to affect their premiums, and therefore they're going to save insurance premiums if it's not filed under workers' compensation. The problem with that is the quickest way to drive somebody to an attorney is to not deny them medical treatment when they need it. Yeah. So that's the person who's going to come in to see an attorney, and then they're, statistically speaking, if they have an attorney representing them in the case, they're going to have a much greater recovery at the final end of it. So the actual cost by their insurance carrier is going to be greater in all likelihood if they play games with the injured worker at the start and drive them to an attorney.
Wow. And I guess that's just short-sighted, but usually a lot of guys do that. I mean, they want to play games here. They want to kind of run the guy around. No, you got to go to the company doctor. This is the doctor we're going to send you to. We're going to send you to Dr. Jones over here. He's really, really good.
Exactly. And you'll see that game played as well. And in Kentucky, they do it, but it's not legally correct. There's an employer locally. I'm not going to name any employers out here, but right. There's an employer locally, unless they've changed their practice in the last year, they would give their injured workers a form, and one of that forms is you have to see the doctor we tell you to see. And that is completely against Kentucky law. Kentucky law specifically says that the injured worker gets to choose their physician, their doctor that's treating them. And even, actually, it says medical provider. So you choose your doctor, you choose your pharmacist, you choose where you want to go for physical therapy. You get to choose who does your diagnostic studies. So if your doctor orders an MRI, they can't tell you, well, we want you to go to Paris, Tennessee to get your MRI because we can get it $100 cheaper than we can get it done here in Murray, Kentucky, or done in Paducah, Kentucky. So the injured worker gets to decide all of those things.
And again, I'm going to ask that question. Mm-hmm. Why would a company want to do that? Why would they want to tell you to go to Dr. Jones versus someone you might select?
Because they perceive that Dr. Jones is favorable to them, and there is a Dr. Jones locally.
We're not talking about that.
We're not talking about that Dr.
Smith or Dr.
We're not talking about that Dr. Jones. But they perceive that the company doctor is going to be more favorable to them. And frankly, from my experience, that tends to be the case. I've seen company doctors release people to go back to work without any restrictions when they had MRI evidence of a herniated disc pinching a nerve. And so that's kind of an odd mix that I wouldn't think that normally a family doctor would not release someone to go back to work without any sort of restrictions in that setting. So they do that because at least they've got a relationship with that company doctor. That company doctor sees a lot of their injured workers from that perspective, and they have a rapport with that doctor that they may or may not should have with
it probably helps both of them. The doctor is getting referral fees, getting all of this, and the doctor in return might be trying to get the workers back to work possibly before they're ready to go.
Correct. The doctors get paid for their treatment. I don't think they get a referral fee, but
right.
they
get a flow of clientele.
There's a financial benefit to them to seeing those patients, obviously, from that standpoint. Now, there's one caveat to what I'm saying, and it doesn't change that you get to pick your doctor, but in Kentucky, the employer and the workers' compensation carrier can have a managed care plan. And what a managed care plan is, just like on private health insurance, if you've got a managed care plan, you have to stay with a doctor within that plan. They have to have provider choice for you within that plan. So the doctors, the family doctors within that plan, you get to pick which one you go to, but they can limit you to staying within that plan if they have a provider care network.
And that's not the norm. I mean, that's kind of the exception to the rule. Not every company has that.
Yes, it's not the standard practice. There's a few employers that the carriers have a managed care network, but the vast majority of employers I deal with do not have a managed care network.
So coming back to the original discussion here, you've got somebody that's been injured. They've given notice. Now what happens? They're on their way to get medical treatment?
Yes, you need to go get medical treatment. If you feel you need to get medical treatment, get medical treatment. And I've had places who have a company nurse, for instance, say, well, I think you're going to be okay. You don't need to go to the emergency room today. Call me tomorrow and let me know how you're doing, and then we can decide. The company nurse doesn't dictate whether you go to a doctor or not. If you feel you need medical treatment, then you go seek medical treatment. And what you can run into at times is the medical provider will say, I'm not going to see you without the workers' comp, or the company saying they're going to pay the bill. And there's not a real good answer to that. Unfortunately, I wish there was. There's not a real good answer. So my advice normally to people is to go to, if you've got a family doctor that you have a relationship with, go to that family doctor, because you're a whole lot less likely to have that kind of a response from a doctor who has a relationship with you already than you are from someone who doesn't know you from Adam. And there's other reasons why it's a good idea to have your own family doctor and see them on a regular basis. This is just another reason why that's a good idea.
Right. So at that point, under Kentucky workers' compensation law, I mean, kind of, what are some of the benefits now that injured employee, that injured workers entitled to?
Yeah, the benefits that a worker's entitled to under Kentucky's workers' compensation law, there are potentially 4 types of benefits that you become eligible for when you've been injured on the job. The first is medical. The employer and its insurance carrier are responsible for all reasonable and necessary medical treatment associated with a workplace injury. And frankly, that's the most valuable benefit, in my opinion, under Kentucky's workers' compensation law. There's no copays, there's no deductibles for that treatment. So you get your treatment covered, and it's not just while you have the acute phase of the injury, or the initial injury and the initial treatment. In Kentucky, the medical treatment, it can vary depending on the date of injury now, because the law recently changed. It changed in July of 2018. Before July of 2018, if you were injured on the job, you were entitled to lifetime medical treatment for the workplace injury. No questions asked, you got lifetime medical if it was a permanent injury. Now, after July of 2018, when you have a workplace injury, you're entitled to 15 years of medical treatment and potentially lifetime medical treatment, depending on the nature of injury or what type of treatment you have, and if it's likely to cause medical treatment that's needed in excess of 15 years.
As is the case with a lot of injuries, it's unique to that particular situation. Just because your buddy further up the line got this doesn't necessarily mean you will. The facts in all of this is unique. I mean, how your body's going to respond to a surgery or to a medical treatment or some physical therapy is going to be different from somebody else.
Yeah, obviously, if your injury is a carpal tunnel syndrome and you've had carpal tunnel surgery and you're not having any problems with it 5 years down the road, your entitlement to medical treatment, your ability to try to get lifetime medical treatment is going to be much different than someone who's had a lumbar fusion surgery who has a prosthetic because of a workplace injury. And those individuals are much more likely to get lifetime medical treatment. In fact, I think with a prosthetic, it's automatic that you get lifetime medical.
Right, because those wear out. There's further surgeries that may be required, things like that. So you're going to have a lot more issues that have already been identified. This is just generally what happens.
And those are conditions that the person is going to need medical treatment more than 15. obviously depending on the age, but they're going to need medical treatment for the rest of their life. If you have a below the knee amputation, those prosthetics are going to wear out over time. You're going to have issues with a residual limb that may need surgery, and to make sure those are taken care of, they make sure you get lifetime medical treatment. So if 20 years down the road you need a new prosthetic limb, you get that new prosthetic limb.
I mean, the way I look at it, Jeff, eventually I'm going to wear out over time. So, but yeah, I mean, that's just the reality of the situation.
Correct. Absolutely.
Okay.
Then,
so that's some medical treatment.
Yes, that's the medical treatment. The second benefit is what's called temporary total disability benefits.
TTD.
TTD. That's what we frequently refer to it as. Is temporary or is TTD. Temporary total disability is what is paid to the injured worker while they are off work under doctor's orders because of the work injury, or if they have physical restrictions that the employer cannot accommodate. So the doctor may not say you're off work because of this injury. He may say you can't lift 10 pounds, and then you go back to your employer and they say we don't have any jobs that you can only lift less than 10 pounds in, so we don't have anything for you. In either of those settings, you get temporary total disability benefits. And temporary total disability benefits is paid basically as an income loss. The rate is generally 66 2/3% of the average weekly wage. The calculation for average weekly wage for workers' comp is a kind of a convoluted process.
With the attorney, for instance, you're going to handle a lot of those calculations and.
Yes, when I get involved, one of the first things I do is I request a 52-week wage history of my client with the employer. So that, and when I get that, I sit down and I look at it and I calculate the average weekly wage the way it should be calculated under Kentucky's Workers' Compensation Act, and then compare my calculation to what my clients have been paid to make sure they've been paid at the correct rate. There is a cap on those benefits under Kentucky law, so if you're a really high wage earner, you may be affected by that cap. And so you may be hit the cap and not receive actually the 66 2/3% of your average weekly wage because of that cap. But then again, I will also look at it and make sure that they've applied that cap correctly in those type of cases as well for my clients.
And I would think like a lot of math problems, those things can be wrong.
Yes. Yeah, well, the cap's going to be what the caps are.
But the cap's a solid number, but how they got to that number or the number they actually calculate, sometimes it needs a second, third pair of eyes on it.
Yes, I've in my career, I've seen several times that the insurance carrier has miscalculated what the average weekly wage should be in a case. Now, it's rarely to the benefit of my client when that happens. I won't say it's never occurred, but it's a rare occurrence that that the miscalculation benefits my client. Nearly always it's a miscalculation paying my client lower than what they should have been paid.
So once you figure it out, that is the benefit to the client, is there's more money coming in.
That's one of the benefit of having an attorney that knows what they're doing in workers' comp, is they can make sure that you're getting paid correctly. And if you're not getting paid correctly, they can they can send a letter or call the insurance company and try to get that corrected. And usually on the average weekly wage calculation errors, I don't really, once I explain to them the error that they've made, really don't see a lot of pushback from the insurance company saying, no, we calculated it correctly. Once I explain it to them, most of the time they will say, oh, yeah, we did miscalculate that. We'll correct the rate and start paying her or him the correct rate into the future, and also go back and make up the underpayment that we've paid all of this time. We'll go back and make that underpayment up.
So sometimes we might call it back pay. That's available under the system as well.
Under that system, yes. If it's been miscalculated, then they're entitled to receive back pay all the way back to when the miscalculation first started.
Wow. Okay.
Yeah.
So when we talk about benefits again, we've got medical treatment, medical surgeries and medicines and things like that. You've got TTD. What else is included?
Now, recently, and I said there's 4 types of benefits, and I've been doing this 27 years, and for 26 of the years, there were 4 types of benefits. They have added in a new category in 2018 called temporary partial disability, and I'll go ahead and talk about that too. Temporary partial disability is, we'll take, for instance, the example I said earlier that they issue a 10-pound lifting restriction. The employer says, well, we can accommodate that, but we don't have a full-time position that's 10 pounds, but we can work you for, we can put you in the office where you're shuffling paperwork, but we only have 20 hours a week available for that. So, and if you don't take that job, unfortunately, the employer would be able to terminate you under federal law, most likely. So if you take that job at 20 hours a week, then that's less than what your temporary total disability rate is. So for temporary partial disability, basically what they would have to do is take what your actual earned wages are, and if that's less than the temporary total disability, they make up the difference to bring you up to the TTD rate there. So, and it's called temporary partial disability. That just started in 2018. We didn't have that in Kentucky until 2018, and it's something that, frankly, we've needed for a while. It encourages the employers to bring people back to work when they can come back to work, and encourages the employees to go back to work, even if it's in a lower duty capacity from that standpoint, but without them having a loss of income when they do that. And so it filled a niche, and myself and several other attorneys that represent injured workers have been advocating that change, and that should be part of the law for several years, and we were finally able to get it at least added to the change in 2018. So,
congratulations. I know there's a lot of families out there that are grateful that you guys were able to get that through.
Yeah.
What if I've been working, now the law's passed, can I go back and get it previous, or is it just going forward from that decision?
You asked me a question I don't know the answer to off the top of my head.
Well, I get 1 week.
Some provisions in the 2018 change were made retroactive, so they went back beforehand. My recollection is the temporary partial disability was one of those that was made retroactive, but I'm not positive on that. So that's another benefit of having an attorney. They can look that up and see if you're entitled to that in the past.
So if you're currently dealing with workers' comp benefits here in Kentucky, you might want to give your attorney a call and just say, hey, I know this law went into effect.
Yes.
Can they gross me back up? Can I get some back pay?
Correct. Yeah. And hopefully if you're still under that light duty setting at this point, it's been a year and a half, actually more than a year and a half since the law came into effect at this point. So hopefully most of those that were before that have recovered enough they're able to go back to work in a more of a full duty capacity. Right. So, but in the temporary partial is just for when you're in the period of recuperation from the injury. If the doctor says that this is a permanent 10-pound lifting restriction, you're at maximum medical improvement, this restriction is of 10 pounds is permanent, then even if you're still stopped at 20 hours a week, at that point, unfortunately, the temporary partial disability would stop at that point in time because temporary total disability would stop at that point in time as well. And so you're not going to get that made the difference at that point. And then it turns over to the third benefit that that I was going to talk about, and that's permanent disability benefits. In Kentucky, permanent disability benefits for workers' compensation claim can be either permanent partial disability or permanent total disability. Permanent total disability is kind of self-explanatory. This injury's caused you to be totally disabled and you can't work. Right. Permanent partial disability is a situation where the person is able to work still, but they have a permanent impairment rating under the 5th edition of the AMA Guides. And unless you do workers' comp, you've never heard exactly. of the 5th edition of the AMA Guides to impairment. But if you have an impairment rating under that book, then you're entitled to permanent disability benefits in Kentucky. And the amount you're entitled to will vary based on a variety of things. What is your impairment rating? What are your physical restrictions? Are you back at work? If you're back at work, are you back doing the same job? What wages are you earning now compared to what wages you were earning before? Your age, your education, and a variety of other things that come into play to determine the exact amount that an injured worker is entitled to in permanent partial disability benefits. But, even if you're back working doing the exact same job, if you've had a permanent injury, then your work life expectancy is probably reduced. And that's where somewhat the reason you have permanent partial disability benefits. So even if you're back doing the exact same job, in making the exact same money, you very well may still be entitled to permanent partial disability benefits, which is designed to try to accommodate or compensate you for the decreased work-life expectancy or the decreased opportunities in the future because of the nature of the injury that you suffered.
And you mentioned a term, maximum medical improvement. Walk us back through, because before I get an impairment rating, I've really got to go through all this treatment. I've got to get all this therapy, all this stuff done to reach a point at where I guess the docs can't really take you any further, right?
Exactly. That's what maximum medical improvement is that you've received the treatment that you need because of the work injury, and you've reached a plateau, and they don't expect that you're going to improve any above that plateau.
And again, that can take many, many months. That can take a couple of years to get to that point, especially if multiple surgeries are involved.
Yes, it can. I've had clients that have been on temporary total disability and did not reach maximum medical improvement for 4 or 5 years after the work injury occurred. That's a rarity, but it does occur with certain injuries. And some people have multiple injuries, right. Multiple body parts injured, and because of the way the body is and maybe the individual themselves, the doctors don't want to operate on multiple different body parts at one time, so they got to operate on this and let it improve, and then they operate on another injured part, or they have problems from the initial and they have to have repeat surgeries and things of that nature.
So ache or something failed, or
exactly, and so it can take a while before someone reaches maximum medical improvement, but as a general rule, most people reach maximum medical improvement 1 year to 2 years after the injury occurs, sometimes sooner and sometimes longer, as we were saying. But essentially, maximum medical improvement is you've got to the point the doctor says, okay, you're as good as you're going to get at this point. And frequently, especially if you're seeing a specialist, what you will hear at that last visit is, instead of come back and see me in 3 months, you can come back. They'll say you can come back as needed. I don't need to see you anymore. Come back as needed.
Right.
And that's a good indication you just reached maximum medical improvement, because unless you're involved in a workers' compensation claim, the doctors probably aren't going to use the term maximum medical improvement, because it's kind of like the impairment rating. It's not a situation where it's a term that's used very often outside of workers' comp or some sort of an injury claim anyway. But when you reach that maximum medical improvement, that is at the time when the attorney will first off, the temporary total disability or temporary partial disability benefits are going to stop, and that's when the attorney will get the information from the doctors to have them provide the impairment ratings, the physical restrictions, and various other things. And it may be the time, if I'm involved, depending on who the doctor is. Some doctors don't do impairment ratings; they don't do permanent restrictions. It may be the time that I then set the person up with a doctor of my choosing to have the doctor assess impairment rating and permanent restrictions.
Because those are somewhat subjective, aren't they?
They can't, they are subjective to some extent. The impairment rating is depending on the nature of the injury. If you've had a cervical fusion surgery, then the AMA guide says you have a 25 to 28% impairment, and it's subjective on which number they give in that, but it's got to be one of those numbers between 25 and 28. But some conditions, it could be as wide a variety as a 1% up to 15 or 20%, and it's subjective to the doctor on which one they're going to impose in that regard.
And so realistically, on that scale, the higher the impairment rating, the less work you're going to be able to perform, so therefore the compensation package from workers' comp should be a little bit higher.
Correct. The higher the impairment rating, generally the better the higher the permanent disability benefits are. Right. For that. There's various other factors that can come in. If you've got a little bit higher impairment rating, but you're back at work doing the exact same thing, making the same money, and your friend who worked with you had an injury and he's got 2 or 3% lower impairment rating, but they're not able to get back to work and earn the same kind of money, then they actually may get more money than you, even though their impairment rating is less, but their actual occupational disability is greater because they're not able to get back to work.
And again, everything is case specific. So whatever happened to your buddy doesn't really have a bearing on your case.
Exactly. It does not have a bearing on the case, and the attorney should be treating every case on its own merits and advising the clients based on that client's specific case.
Right. So in terms of other benefits, I mean, we've talked about you've got medical treatment in there, you've got temporary total disability, you've got the temporary partial disability, and then you've also now reached maximum medical improvement. You've got an impairment rating. Where do we go from there?
Well, in addition to the permanent partial disability or permanent disability benefits, the last benefit that you can be eligible for under Kentucky's Workers' Compensation Act is vocational rehabilitation benefits. If because of the injury and the physical restrictions placed on you because of that injury, you're not able to go back and do the work that you've done at the time of the injury or other work that you've done in the past recently anyway, then we can look at getting you retrained into another field. And that can be very helpful for clients. Even if you're permanently receive permanent total disability, if we can retrain someone, that will open up job avenues that weren't open up to them beforehand. And, my advice to clients in my office is nearly always, if not always, that you're better off physically, mentally, and financially working. If you can work, then you are not working. Anybody who's been out of work for a period of time and wondered how they were going to pay their bills and worried about, if they're going to be able to afford to send their kid to college and things of that nature, they will tell you that not working is mentally challenging to someone. Not just physically. You don't have the physical issues. You got a mental problem associated with that, and it can cause some depression and other things there. So if you can work, you're better off, as I said, mentally, physically, and financially, because you're going to make more money working than you're going to make on workers' comp.
Because, realistically, if you're found totally disabled, okay, yeah, you're going to have benefits, there, but you can't go out and pick up trash on the highway for a couple bucks here or there. You are totally disabled.
For workers' comp purposes, it is any work at all. So if you can go out and do any work, you're not permanently totally disabled for workers' comp purposes from there. And also and I've represented clients who were in their 30s and were found to be permanently and totally disabled because of the severity of their injury. One of the problems with Kentucky's Workers' Compensation Act that myself and others have tried to fix, but unfortunately have not been able to fix, is there's no cost of living adjustment.
Wow.
So, I had a 30-year-old client in 2000 who had a work-related injury, and he's getting permanent total disability rate for 2000 for his wages in 2000 with no cost of living adjustment. And, the cost of living has increased significantly since 2000. So, every year, his spending power is going down because he's on a fixed income, so to speak, with no cost of living adjustment.
And Kentucky law right now doesn't really provide for an avenue for him to get that reconsidered or renegotiated or whatever you want to call it.
It's impossible under Kentucky law right now for workers' comp.
For workers' comp. And that kind of completes that area of the discussion in terms of the benefits that you're able. But you're one of those attorneys here in Kentucky who actually handles another area. You handle, as we talked about in episode 1, you also handle Social Security disability. And that may be another avenue, another source of funds for a client. You want to talk about how those can maybe come together? We won't spend a ton of time because we'll probably do a separate episode on that coming up. But you want to kind of, as long as we're talking about this kind of disability payments.
Sure. The two are not, workers' comp, Social Security disability are not mutually exclusive. A lot of people think they are. They think, well, if I'm receiving workers' comp, I cannot receive Social Security disability, or if I'm receiving Social Security disability, I cannot receive workers' compensation benefits. And that's not correct. Social Security disability and workers' comp in Kentucky do have some interplay. But if you're injured on the job and you're totally disabled as a result of that injury, then you should not only seek permanent total disability benefits under Kentucky's Workers' Compensation Act, but you should seek Social Security disability benefits as well. And I frequently advise my clients to do that and represent them in both the workers' compensation and the Social Security disability claim from that standpoint. And I've had this happen with clients of mine in the past who were disabled by Social Security disability standards. And Social Security disability is different than Kentucky Workers' Comp from the standpoint that Kentucky Workers' Comp is total disability, means you can't do any work. Social Security disability is a little different. You can sometimes do part-time work and be on Social Security disability. And I've had clients who were receiving Social Security disability and then working a part-time job, which is all they could do, but working a part-time job and then get injured on that part-time job and then think that, well, they can't pursue a workers' compensation claim because they're already disabled from the Social Security disability. And that's not true. If you are working and you're injured on the job, it doesn't matter if you're on Social Security disability or not, you're entitled to or can be entitled to Kentucky workers' compensation benefits. Obviously, you have to be injured in Kentucky, but or a claim that's covered by Kentucky law.
Right. Jeff, buddy, I appreciate it. I mean, you've got a wealth of knowledge. You've been doing this for 27 years. I mean, you've seen a lot of cases over this career, and you kind of handled a lot of different situations and kind of sat across the table with people, who are looking to you and just saying, can you help me?
I have done that. I've done this for 27 years, and I have clients that sit across my conference room table and we talk about their situation, and every situation is unique and every individual is unique. But you're probably not going to say something to me that's going to shock me or be something that I've not heard and that I've not helped another client address and work through in the past. And that, that experience in having been through the process before with someone else can really help a client now, because in my job as their attorney is to do the best I can for the workers' compensation claim or whatever type of case I'm handling. But you'll have clients tell you this, and if you look on my on Google reviews and all of those, you'll see clients say this. But I also take my role is not just to maximize the benefits in your workers' compensation claim, but my role is also to make sure you get the absolute best medical treatment that you can get for your condition. And, I don't direct anybody to see any specific doctors, but I know what doctors do a good job on certain conditions, and I may make recommendations that you look at this doctor or look at these doctors, for instance, but getting you the best outcome so that you're physically the best you can be. I think that's part of my role as well, in having the years of experience that I've had and seeing the vast multitude of different medical conditions that I have helped me to I think, not only do a good job for my clients in their workers' compensation claim, but also to make sure that at the when they reach maximal medical improvement, they were actually better or are actually as good as they can be for that condition. And I've recommended people go. We have excellent doctors in Western Kentucky. There's a lot of excellent doctors in Western Kentucky, but there are some conditions that there may be a doctor in Nashville that treats it on a regular basis, and the doctor here in Western Kentucky sees one case or two cases a year. Right. And so it may be better off for you to go to the specialist there to look at it, just the same that it's better if you go to an attorney who handles workers' compensation cases day in, day out than someone who handles a workers' comp case once every 6 months or once a year. And it's the same with a medical specialty, in my opinion. If you got someone who's a super specialist in that area that is close and is readily accessible, and we can get the workers' comp carrier to pay for it, then that's who we need to.
You not?
Yeah, exactly. That's who you need to be seeing.
Yeah, that makes sense. Jeff, buddy, I know you're busy. I appreciate your time, and I hope for those who are listening, this information's been helpful. There's probably a lot of questions going through your mind if you've been injured, or your family member, your spouse, or your child's been injured on the job. And I've known Jeff for a long time, and I can't tell you the number of Google reviews I've read about him, the number of comments I've seen from clients, either on his website or out on Facebook, different places like that. And I'd encourage you to give him a call. Jeff, what is the best way for someone to get in touch with you?
Best way to reach me is to call me. I prefer verbal communication over emails, but you can get in touch with me by email as well. The phone number is 270-753-0053. You can reach me by email at jeff@jeffrobertslaw.com. Also on my website, if you go to my website, it has a live chat function on there that they can get some information from you. I have some people who man that site. There are not actual people who work in my office, but they man that site for me 24 hours a day, 7 days a week. And when you talk with them, after that communication is over with, they will send me an email of the communication and also send me a text message letting me know that they've sent that email to me. Yep. So even on the weekends, I may get that text message, and if it is an emergency situation, I'll try to respond to you then. From there. But the phone is my preferred type of contact.
Right. Buddy, I appreciate it. Congratulations on episode 2. And friends, we'll be back in 2 weeks with another episode. I hope you continue listening, and thanks for your time.
Thank you.
Bye-bye. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.